Hey y'all, today we are going to be talking about Darrell Brooks again. Darrell Brooks, he said that they didn't put the shock collar on them legs, y'all. So Judge Dorrow, she had to, shut him down, open up shop. So she said there were no shackles, shock restraints on your legs during these trial. They just, put something else on, but it wasn't no shock thing. But y'all, I don't know if that would be even legal. But sometimes you have to treat people how they act, and maybe they thought that that was the best thing for him. I don't know where he got that from, but maybe he was just trying to prolong the trial, y'all. That's just me. I'm just saying he tried to prolong the trial and say that these were shock restraints, but I'm not sure what the laws are in Wisconsin about putting shock restraints on inmates. I'm not sure. We have to look that up. But yeah, here's the video, y'all. So the title on this one is Judge Shuts Down Darrell Brooks Claims Over Shock Restraints, y'all. So let's get this video started, y'all.
The clerk's office is instructed that first thing tomorrow morning, they may unseal all of the search warrants in this case. The next issue I want to address is I want to make a record specifically as it relates to the restraints that the Sheriff's Department utilized during this case, given a comment made by Mr. Brooks when the jury was coming out the very last time. I don't recall if you said something about a stun belt or shackles or something to that effect, but it was inaccurate. I have asked the Sheriff's Department to provide photographic documentation of the shackles that were utilized in this case. The parties will recall the tables look a little different now because there are no table skirts on them. On all defense tables in the secure courtroom, there is a ring. It's really more looks like a rectangle that is attached to the leg of the table, and an inmate who's in custody but in trial, a soft restraint system is utilized, primarily so it's soft and not heard, and then it's attached to the table so that it confines the inmate to a small area with that table. Obviously, during the trial, Mr. Brooks was able to stand. His hands were free, but I felt it important to have a thorough record of the restraints that were utilized. The photographs that have been provided are on a compact disc. They will be filed as.
See, y'all, this is where I'm talking about how Judge Dorrow is very, very smart, very intelligent. She's not going to do anything without proof or validation, of course, as she should, because she's a judge. You want to make sure that if somebody says something, that there's clarification through pictures, through some type of evidence to prove whatever they're trying to prove. Which here they're trying to prove that Darrell did not have any shock restraints on. So y'all, let's continue.
That's Court Exhibit 3, but they will remain under seal. And that is because of the security concerns related to how the Sheriff's Department secures inmates during a trial. That certainly is an overriding interest, overriding any public interest to see what those restraints are. And I would just further note that during the trial, when Mr. Brooks would be brought from the holding area into the courtroom, this courtroom was closed to the public. And that was really to maintain that privacy, if you will, or secrecy, if you will, regarding the restraint system. And so I believe it's important that that information not be released to the public. It will be available, of course, to the court and the parties. And if there is an appeal, any attorney that may represent you can certainly look at that, but it'll otherwise be under seal. So
why would that?
The record is very clear on the restraint system that was utilized during this trial.
I have a question to that.
Okay.
Why is that remaining sealed, but everything else being open to the public?
I've indicated my reasons are on the record. I'm not going to restate them. So
well, I think that the public, if they're allowed to see search warrant information and things like that, then I think that they should know that it was a shock device on my ankles. That
There was no shock device
It
on
was
your
a
ankle,
shock
sir.
device. I was told it was a shock device,
Mr. Brooks,
and
that's
it was
why I'm
covered
making
up.
the
It
record.
was covered up.
Y'all, where do they do this at? I'm just trying to figure out because Darrell Brooks, I think he just be like to make up stuff because he's trying to prolong, of course, him, his trial ending or whatever, and him going to the big house. That's just my opinion. Y'all let me know what y'all think. But he's just throwing all kind of everything that he could to try to, stop it and, basically waste time with the judge and in the courtroom. He was doing it. This took, I'm not sure exactly how long. I would have to look it up, but this video by itself is 45 minutes, almost an hour. So y'all, that even if it was like a half hour total straight through, that's 30 minutes, half an hour wasted of the court's time because he wants to prove that there was shackles with shock restraints, around his ankles. But y'all, Darrell Brooks, he is so bogus, y'all. But let's continue, y'all.
Covered up by a black cloth, so the jury purposely could not see it, and so that the public cannot see it. I was told that a chair had to be placed on my side so that no one can see that I was shackled with ankle shocks. I think the public should know that. The jury should have known that. That's what they were.
Mr. Brooks, I've made my ruling. Your
I
characterization
respect your
of
ruling,
those
but it should be noted.
Your
It should be
objection is
noted.
noted for the record.
It should be noted that I had a shock device on my ankles. That's fact. It's a
not
fact.
Y'all. Now, if they do some kind of shock restraints or whatever, would y'all blame the judge or the law enforcement there, the way he's been acting? Do y'all blame him? Blame them for having to use the shock restraints if that was true, if that was the case? I'm not sure if it is or not. But the way he's acting, some people, they got a saying, you treat people how they act, right? He acting like an animal. So they say, that they put shock restraints on animals. I'm just saying, y'all, you get treated how you get treated, how you act. So let's carry on.
It is a fact. I'm the one that had them on my ankles. I inquired about what they were. Obviously, I'm going to require about what's being put on my body. I was told that there were a shock device, which I know how a shock device looks because I've been through this before in Milwaukee. So I know what a shock device is. It was clearly a shock device that was purposely not shown to the jury or to the public.
Y'all, did Dorrow just say he knows? He's like, I don't know his exact words, what he just said. Something about like he knows because, hold on, let's back it up a little bit. Let's back it up just a teeny bit. Let's back it up. Let's see.
Had them on my ankles. I inquired about what they were. Obviously, I'm going to require about what's being put on my body. I was told that there were a shock device, which I know how a shock device looks because I've been through this before in Milwaukee. So I know.
So y'all, Darrell Brooks said he'd been through this before. And if they have to use shock restraints, quote unquote, according to, what his mouth is saying, that means he was acting the same way whenever they supposedly use them last time. That ain't nothing changed but the day and the time. So he's been acting crazy like a wild animal, like according to what he's saying. Basically, that's how I'm taking it, y'all. Now, y'all, this is my own perspective of it, y'all. Y'all let me know what y'all think in the comments, because that's what I'm getting. Okay, let's carry on, y'all. Let's carry on.
No, I know what a shock device is. It was clearly a shock device that was purposely not shown to the jury or to the public. Purposely not. And then now you're saying that it's going to be sealed. Well, why should it be sealed? The public doesn't deserve. The public deserves to know.
You've made a record,
and it's noted. To know about things pertaining to a search warrant, but not the fact that I was limited by a shock device. That if I moved the wrong way, I could have got shocked with all this voltage.
It's absolutely false that you have a shock device
false,
on,
and
sir.
you know that it's not false.
Well, I have the photograph.
Well, show
that will be part of the record.
Where's the photographs?
And they will be
just said they would be sealed. Why do they need to be
from public
sealed?
view
Why
For
do
the
they need to
reasons
be
that I've
sealed from the
already
public?
indicated.
Why do they need to be sealed
Mr.
from
Brooks,
the
I
public?
need to move on to scheduling.
Can we move on to subject matter jurisdiction that hasn't been proved for the record?
All right, so
Can we move on to that?
Mr. Brooks, I really don't want to remove you from the courtroom today. But
I
I need to
don't,
move
I don't
on
want to be removed, but you're not going to sit here and tell me on the record what was on my body when I was told what it was. That's inaccurate. And I refuse.
At a
Your
later
Honor,
point in time, I
Your
will
Honor,
put.
I refuse to sit here and let you make an inaccurate record when you know that it was in fact a shock device. That's why I had the black cloth.
Y'all, Darrell Brooks is on trial for murking. And he comes into the courtroom being, like I always say, so disrespectful on so many levels, y'all. I mean, right now he is going back and forth with the judge, y'all. No home training. That's all I'm gonna say. Let's carry on. No home training. Just saying, y'all.
In front of the table so it couldn't be shown. That's
not
why I
right
had a chair sitting on the side of me that was told needs to cover up the fact that I had a shock device on my ankles. And I think it's very, very, very unfair, and it's dishonorable to get on a record and not tell the truth. I'm not trying to dishonor you, Your Honor. I'm not trying to disrespect you. I'm not trying to disrespect your court. I just want the truth to be told. That should not be sealed. If everything else can be open to the public, then the public should know that I had a shock device on my ankles. That was purposely not shown to the jury or to the public. They should know that.
All right, thank you, Mr. Brooks. I disagree wholeheartedly with your characterization.
It's not true.
Mr. Brooks, I didn't interrupt you. Please
It's not
don't
true.
interrupt me.
It's not true.
Mr. Brooks?
I respect Judge Dorrow's, she had to, seal these pictures and the restraint or whatever, because and these are just my thoughts and my opinion, or what I kind of gather from it. But that it's like the police, you can't request the police force to show all their guns and all their weapons that they use to go do raids and stuff like that. I kind of gather that kind of like right along those lines. Like, you're not gonna ask them, to see that. So why would you ask for everybody to see the shock restraints? They'll be doing the most, y'all. Let's carry on.
I'm quite sure it's cameras rolling right now, because there are always cameras rolling. There's always audio on.
Mr. Brooks, I need to move on to
There's
scheduling.
public in the courtroom. I had a shock device on my ankles, and they purposely did not want to show that to you guys or to the jury.
Mr. Brooks, I'm advising you.
Here or here.
Mr. Brooks, I'm advising you.
And I always had the chair right here. Everybody that came to this courtroom seen that I had a chair right here, even though I had no counsel. What is the reason for me to have a chair right here?
All right, Mr. Brooks,
Why
any
did I have a black cloth
further
in front of the table?
interruptions will result in you being removed to the other courtroom, because you're not letting move on to scheduling.
Y'all, do y'all see why he probably did have some shock call? They say he didn't, but even if he didn't, the reason why he needed some shock call, the law enforcement would possibly put a shock collar on him. I mean, look at the way he's acting. He's arguing back and forth with the judge. I'm like, I just don't understand. I don't understand. I do not understand. Like, that's why they got him so tight in the shackles, because they already know how he acts. He's very disrespectful, and he acts like an animal. So they're just treating him, according to how he's acting, because he's being disrespectful, and they know that, he gonna act out. But let's carry on, y'all. Let's carry on. Let's move forward.
Is it civil contempt or criminal contempt?
All right, one more interruption and you will go to the other courtroom.
Well, they need to know that.
Stop.
They need to know that. They need to know the truth.
I'm going to ask the state some questions. If you interrupt when I do that, you will be removed to the other courtroom.
Remove me then.
All right, Attorney Basie.
It's not going to stop the fact that they need to know that the shock device
he's interrupted. I'm sorry, everyone. We'll have to clear the courtroom. He will be removed to the other courtroom. I'll make the appropriate findings.
Tell the truth, though, Your Honor. Tell the truth. I had a shackle. I had a shock device on my ankles.
Please see you. We're off.
Whenever she puts about the courtroom, the cameras automatically always go to the flag. But y'all, this is wasted time. This is wasted time, but that's what Darrell wants. He wants to sit here and waste the judges' time, the court's time, because he want to sit here and argue and debate over what he wants to argue and debate over instead of just keeping his mouth shut and being respectful, y'all. I just wasting time. I'm gonna fast forward it just a little bit and check where they come back in at. I mean, y'all, this is time. Look at, okay, we're back.
Removed him. All right, he interrupted. I will mute him. I need to make a record of his removal. The court did warn Mr. Brooks repeatedly that if he continued to be disruptive, the court would remove him to the other courtroom. It was my sincere hope that that would not need to take place today. I gave him the final warning, and then I indicated I would be turning to the state to ask them some questions, and if he interrupted that process, he would be removed. He immediately interrupted that, and so the courtroom was closed. He was put into the other courtroom. I have confirmed that the audio and visual technology is working. He can hear, he can see, at least the other individuals in there confirmed that that was the case. He was audible for a little bit when I first went on the record, but he continued to be disruptive. And so I did utilize the mute function of the technology so that I could make an adequate record. Although this is really a scheduling hearing today, I will make a finding under Illinois versus Allen that his conduct was did disregard the elementary standards of proper conduct, of decorum and courtesy. He was disruptive. He interrupted.
Bam. Did y'all hear what Judge Dorrow said? She said of elementary. Did y'all? Let's kind of do a recap real quick. She said elementary. Let's see what she said again.
Confirmed that the audio and visual technology is working. He can hear, he can see, at least the other individuals in there confirmed that that was the case. He was audible for a little bit when I first went on the record, but he continued to be disruptive. And so I did utilize the mute function of the technology so that I could make an adequate record. Although this is really a scheduling hearing today, I will make a finding under Illinois versus Allen that his conduct was did disregard the elementary standards of proper.
Did disregard the elements of elementary. Basically, she said that you acting like a child. That's how I'm taking it, y'all. Let me know what y'all think. Okay, let's carry on, y'all.
Conduct of decorum and courtesy. He was disruptive. He interrupted multiple times and challenged this court when this court was making a record regarding the restraints that were utilized throughout this trial. I'm not going to do it today, but I will at a later point in time. Perhaps after scheduling, I will have a deputy testify regarding the restraints that were utilized so that there is a full and complete record about what was utilized and what was not utilized throughout this trial. It is absolutely false that a stun belt of any kind was used on Mr. Brooks. I don't know if he's receiving that information from other inmates, but that was not utilized.
She said a stun restraint of any kind. So whatever Dorrow is trying to claim, she confirmed it with the law enforcement that there is no kind of restraint on his leg that renders shock, like a shock restraint, like he's saying. They confirmed it. Let's carry on, y'all. Dorrow, he's
in this case. It was a soft leg restraint setup, if you will, where he was shackled his ankles with the soft restraints and the soft strap so that it did not make noise. That was all attached to the table. And it is absolutely true that there was a black table skirt on the tables, both the state's table, the defense table in this courtroom, despite Mr. Brooks believing that it was not done for his benefit. It was to shield that information from the jury. It's also true that at all times when he has been brought into court, it's been before the court has been open to the public. If this court needed to remove him to the other courtroom, it was also done with the courtroom closed to the public. That was, of course, a security decision made by the sheriff's department. They are in charge of his security as well as the court's security during any court proceeding in this courthouse. And it was their discretion and decision on what restraints would be utilized. And again, I'll go through that later and have a record made of what was utilized, including having one of the deputies identify what's on the exhibit. I'm not going to show that publicly. Again, there are security reasons. We don't, frankly, need inmates doing research or the public doing research on what these restraints are. There's an important security aspect related to keeping courts safe, keeping inmates safe, and that is why I'm sealing that information from public view so that their protocols and practices have that, frankly, veil of secrecy. It's important given the security issues. It's a law enforcement function, and that is my decision on that.
See, Judge Dorrow said that is like law enforcement and security. They're not gonna show, what kind of, items that they use to restrain criminals. They're not gonna do that. They're not gonna post it. Like I said, it's like them posting their weapons, on what they use when they go on manhunts or something like that, or when they go apprehend somebody. They're not gonna do that and show, what they have for a criminal to be ready for them. That's just really, I don't think that is, I don't think that's like legally the proper thing, I guess.
As far as Mr. Brooks being in the other courtroom, again, I did that pursuant to the authority found in Illinois versus Allen. I did not hold him in contempt. Frankly, because it's a scheduling type hearing, I could simply have him taken back to the jail and he could appear by phone, but I've chosen to have him appear by video and audio means from the other courtroom. With that, I am going to address scheduling. I will be asking each party in turn how much time they believe they need to present their various sentencing remarks and whether anyone will be speaking on behalf. So I'll turn to the state first.
Thank you, Your Honor. To date, we have indications from the victims or their families that 36 people would like to either have a statement read or they'd like to read it themselves. We have approximately 5 to 10 others that would like to submit one in writing, which obviously wouldn't impact the time that we would need on the sentencing date. I would think that the state's comments would be between a half an hour to 45 minutes in total. So we're looking probably at about 4 to 4.5 hours. We will need some time to rotate victims out of the courtroom as they come in and to speak, because we can't fit everyone in the courtroom at one time. So we'll need to get one set in, get another one to room 115 so that they can hear what's being said. So we're thinking.
Y'all, this is a very high profile case. If y'all didn't know, Darrell Brooks is accused of, like I said, murking people and a few children and injuring quite a bit of people at this parade. What he did, he was angry for some apparent reason. He took his truck, his mother's SUV, and he, like, when they were having their Christmas parade, he just ran those people over. It was awful, you guys. It was so sad. It was really, really bad. But he took his mother's vehicle, like a small SUV, ran through the crowd and did what he did. Yeah. So the courtroom, and I'm sure outside the courtroom at this time, was probably packed, because this happened, of course, December timeframe at their Waukesha, Wisconsin Christmas parade. And his trial happened that next year in like November. So they were trying to hurry up and get his trial over with before the year anniversary of his the parade, of when this situation, awful tragic situation happen. So yeah. So they have to be careful, safety measures, have to be in place in order to, people to come in and out, freely. Yeah. So, I mean, not freely, safely. So let's continue, you guys.
Thinking 4 hours, and speaking with the families and the victims Wednesday after the verdict, I think there's a strong desire to have the sentencing before the anniversary of the parade incident, and that obviously is November 21st. In checking with people, November 15th, 16th works for everyone. Specifically, the 16th works for everyone that would like to talk. I know that this court obviously has court calendars. I do have other dates that would work. Unfortunately, those go out to the end of December, end of November, beginning of December. But again, I can't emphasize enough. There are a lot of families who are leaving town the week of the parade, and I think the general consensus would be it would be nice for them to have some finality to this before they leave, so that they're not around here at the time that a loved one was injured or killed.
By any chance, did you have an opportunity to look at my calendar and some of the jury trials and talk with your colleagues? I mean, one of the cases, for example, I have on the 15th is an attempted homicide trial. I don't know if that's going to go or not, but just like this court gave due attention to this case, I need to be mindful that that case has been scheduled since June.
I did not.
See, you guys, here the judge is talking about, basically respecting the court's time, because these trials have to be set up in accordance to probably, what kind of trial. That's why she specified what kind of trial that was, that was going to be going on. So they make sure that they don't collide with the schedules, or if something goes over, like Darrell, of course, wasting everybody's time, wasting time. They want to make sure there's adequate and sufficient time for these court cases to to go on to happen. All right, let's carry on, y'all.
I received these dates, although I believe that they were
This is my dog Checkers. She's 21, and I owe it all to the farmer's dog.
Checkers commercial.
Probably sent this weekend. I did not check my email over the weekend, so I did receive them this morning, and unfortunately, I did not take the time to do that. We can certainly look right now. Do you know who's handling that attempted homicide from our office?
I believe that's Attorney Sitzberger.
Okay.
There's other cases as well, because it's rare that I wouldn't stack trials. Right. And so there's also another serious felony matter with Attorney Thurston for your office. That one was scheduled in August. I have another one with you, yes. Attorney Basie. I'm just looking at the number of.
So basically, Judge Dorrow did shut down what Darrell was talking about, that he got shock restraints on him. But like I keep on saying, you treat it how you act. I mean, look at the way they have the shackles on his hands, because he don't know how to act. He does not know how to respect authority, for one, and he don't have respect for anyone at all. I mean, he's been going to these court cases. I'm sure he's been acting up when he was being held at the local county jail during his trial. I'm sure he was doing all kind of things, doing the most while he was in there at the local level. But y'all, he just wanted to put this in here, and this is my opinion. He just wanted to put this in here so he could waste time. And you see, Judge Dorrow don't got time, to be dealing with Darrell Brooks and his shenanigans, y'all. She just don't got the time, But my thing is, look, Darrell is doing the most on the coast. He anything that he could do to prolong this case, y'all. I don't understand. And now, from what I'm hearing, one of the comments, somebody left a comment and said that and this is alleged because I cannot confirm nor deny, you guys, but when he got over there into that prison ground, he was, there's some comments in the comments on my on my shorts, but somebody was saying that basically he got his butt handed to him, as he should, because like I said, people know when to shut their mouth and be respectful, especially when you're in court and you're dealing with the judge. You don't go in there debating and going back and forth with the judge, telling the police to get off of you. And Darrell was doing the most, y'all. The most. And he's going to court for murking people. He ain't in court for a traffic ticket or, stealing something or kidnapping or, breaking the law in any other way, shape, or form. He's in there for murking numerous people. He has devastated the city of Waukesha, Wisconsin, and he is going in there disrespecting even the victims' families, y'all. During cross-examination, he is doing the most, like no respect at all. None. So he is lying. I think, my opinion, y'all, he's lying saying this. And and it may be for attention too. He may be, well, as we all see, he's a attention seeker. He's seeking all kind of attention, saying stuff, doing stuff, there's cameras rolling and blah blah blah. We know there's cameras rolling because this is a high profile case. Darrell is doing the most, doing the most on the coast, y'all. And I cannot believe that he is asking for an appeal. So y'all, I want to touch on that too. So let's go find Darrell Brooks. Darrell Brooks asking for, let's see, Darrell Brooks requesting he wants to request an appeal. How are you going to request an appeal? How are you going to request an appeal? I'm telling y'all, Darrell Brooks is doing the most. Darrell Brooks appears in court. Okay, no. He asked for a let me see. He asked for an appeal. Okay, that was a year ago. Okay, that I remember that. Yeah, Darrell Brooks files notice. Okay, let's go to this one because this is where he files notice. But this is like literally
2 weeks
right
after a judge sentenced him to life in prison, Darrell Brooks begins his appeals process.
Fox 6's Brett Lemoyne here in the studio with the reason Brooks says this time he does want an attorney.
Yeah, Ted and Mary. In October, a jury found Brooks guilty of killing 6 people and hurting more than 60 others. He represented himself during his trial. Well, yesterday, Waukesha County received Brooks's handwritten letter. Brooks says he wants an attorney to possibly appeal his conviction. A year after causing mayhem and bloodshed at Waukesha's Christmas parade, Darrell Brooks sent this letter notifying the court of his intent to seek post-conviction relief.
Most people think of post-conviction relief or an appeal as going to a higher level court, the Court of Appeals. But post-conviction relief can also mean motions that are filed after conviction, after sentencing, asking the court to maybe reconsider some of the things that happened.
Defense attorney Julius Kim provided Fox 6 with legal analysis during Brooks's trial. Kim says a defendant needs to file this paperwork within 20 days.
Did y'all see how that the police officer, when Dorrow was talking, he kind of stood up because they know he is an aggressive type person. He's really belligerent and very, very, very disrespectful. So they know what they're dealing with, of course. But for him, on the flip side, for Dorrow to ask for an appeals process, he literally just, they just found him guilty. And then as soon as they found him guilty, I remember him sending that appeal. But he got found guilty on all those charges. Like, he's never going to see the light of day. And for him to, I think what he's trying to do is get a vacation away from the prison for him, because once you go and do an appeal, you got to go back to court. So they have to come get you from prison. They have to house you probably at the local or wherever they're going to house him at. But needless to say, it's a way for him to come and go out the out the prison. But yeah. When he was doing the questioning for his child's mother, he was being disrespectful on so many levels. Let me see Darrell. Let's see. Darrell questions ex-girlfriend. Let's see. He was so disrespectful. And another thing, there's so much dealing with Dorrow, but I did not, I know now, but during the trial, as the trial was going on, Darrell, he was accused of grape. He was accused of grape, you guys. He was accused of grape. Yes, he was accused of raping his baby mama. And she was younger, and he was a lot older than her. And then he puts her on the stand, and he tries to humiliate her, y'all. Uh-oh. Uh-oh. I'm sorry, y'all. Hold on just a second. Okay. Okay, y'all. Here is where he cross-examines his child's mother, which is his ex-girlfriend. She was the reason, I'm not saying she was the reason why this happened, but they had got into an argument the day that he went ramming through this parade. So let me hold on just a second. Let me see if I can share this screen. Hold on just a second. But yeah, it is. Yeah, he is. Darrell is awful. He's a sight to see. Let me. Let's see. Let me see. Let me just go back to the main screen. I don't know why my computer is acting up. But anyway, I'm not able to share. But anyway, let me stop sharing, you guys. Okay, there we go. So Darrell Brooks, he put, his ex-girlfriend goes on the stand, and then, he's asking her these questions, and it's like, I can't believe he would even ask his child's mother, but to me, he's a narcissist, y'all. He asking all kind of crazy questions, trying to get her, like intimidate her, like try to scare her, because he'd been doing that really ever since he was with this girl. He was always intimidating her. So anyway, the way that she responded, y'all, I'm gonna have to do another video on that, on his questioning his ex-girlfriend. But anyway, she was like, at one time, she was giving it to him like in a silent way, I guess, per se. She was like, like, this joker has the audacity to ask me this question. Like, who do you think you are? But he had, it's his, right to question her, because he was he was representing himself. But y'all, and then he had another, I didn't know this, he had another baby mother, and she was the one that came and spoke up on his behalf at the end of the trial, as a witness, I guess a character witness. But I'm like, you have this one saying this, and then you have this one saying that. But, he manipulated them girls, in my opinion. He manipulated both of his children's mother. And he also did some awful things to his nephew. His sister, he had a sister, I believe it was a twin sister. She passed away, and his mom took care of I think it was like one or two children she had. So the nephew is LGBTQ. Nothing is wrong with that. Everybody should be loved the same way. But he was like, he was doing some awful things to him, and to where the nephew had to, I believe, get a restraining order on him. He was just doing the most. To everybody. He was traumatizing, humiliating, doing all kind of stuff up. Everybody, just about the way, from what I seen in the trial, just about to everybody. He was awful. He was a piece of work. But yeah, so y'all, Darrell Brooks, it got shut down by Judge Dorrow. She's like, I'm confirming that there was not no shock restraints. And to me, if he did have shock restraints on y'all, wouldn't you think they would have shocked him by the way he was acting? Come on now. They're not going to put no shock restraints on you to try to taunt you or to scare you. You're in the shackles already. Why would they need to put a shock restraint on top of like the handcuffs or in place of the handcuffs? That don't make sense to me. But like I said, it was just something to buy him some time, because like I said, when he got that guilty verdict, it was only a matter of time before he was going to the big house. And like I said on my other video, he knows that when he got to the big house, when he got to the yard, them people was waiting for him. So it is what it is. But Darrell is doing the most. There was not no restraints on his ankles. He was acting, a whole donkey, y'all. This whole trial. And another thing, I only seen his mom doing this trial like one time, and that's when she came on camera and with the news and said that she didn't want to be a part, which I understand her respectfully, because people can be ugly acting towards her, because it's not, she didn't do this awful, she didn't commit this awful crime. It was him. But at the same time, y'all, it's, a kind of a thin line, when it comes to being responsible for, and I'm not saying all the way, but she had to played a part in, of course, his growing up. I believe she raised him, but sometimes, narcissists, I feel like are bred, and it's like kind of like some of it is a learned behavior. That's just me. I'm not no doctor or anything like that, but I did not see his mom, and she didn't even come in. So his supposed grandmother, which was some older lady, which is not really his biological grandmother, that supposedly called herself grandmother, spoke at his trial at the end. And I think his mom did too, I believe. I have to go back because it's been a while since I watched this court case, but this right here, I had to do a quick video on it today. But his mother, she was very, very absent during this trial, which from the looks of it, maybe, she was kind of scared of him too. The way he's acting with the judge, I can imagine how he was acting, with his own. Okay, I'm back. I'm sorry. My internet is awful. We had an internet outage. So anyway, so yeah, y'all, I don't know. But this whole case is just, yeah, it's awful. And I know they said the appeals process, I believe, could take up to years for them to appeal it. And plus they have to go back through all the evidence and everything. And he said that he wants to get a judge to represent him because y'all know, as y'all can see, he didn't represent himself good at all. I mean, he was probably in the law library at that jailhouse. I know they were bringing him probably, you know, all kind of law books or whatever he was requesting. So he was trying to turn into a certified lawyer within however long he was in there, a year or something before his trial. And he did an awful job. I mean, he didn't even know, you know, the proper things. Like he was always saying grounds. Like, you know, there's, you know, it's with anything, you know, you have to say things at a certain time. You can't just be throwing words out there. But he was throwing words out there. He was just doing the most. And he then at a couple of times, numerous times, he was, you know, the judge was asking him something, and he said, well, what do you think I'm supposed to do, or something, basically. And I'm like, Darrell, you trying to ask the teacher for the answers to the question when you should already know the answer. You let her know that she, you know, you was I guess jailhouse certified, allegedly, you know, that you could, you know, you're able to take on your own case and represent yourself. But, you know, you, with a case like this, especially a high profile case, I would have never, ever recommended to do that, you know, to nobody, you know, for anybody. I mean, I would never be in that situation, but at the same time, you have no expertise in the law. You don't know how to, you know, use certain laws to apply it to certain situations during the case. But, you know, Darrell do what he want to do. I mean, allegedly, I mean, just from what everybody see, y'all, Darrell is off the chain. Y'all hear me? He is off the chain. I'm just trying to figure out, you know, I wonder how he's being treated in there. I mean, I know they said that he was, you know, they handed him his butt, you know, while he's in there, but y'all, that mouth is slicker than Vaseline. And you know, them inmates, I don't know how big Darrell is, but he don't look like he's a very big dude. However, you know, there's some big guys up in there, and you know, they're not just gonna take him talking crazy like he was to the judge. They're gonna handle that on site. So, but yeah, you guys, so there was no restraints, nothing like that. He's throwing that out there. But I wonder exactly how long it is going to take for them to appeal this. Okay, I'm back, y'all. My internet is acting up, and it's in and out. But y'all, I want to tell y'all, thank y'all for watching my video. Check out my other videos on Dorrow. Check out my shorts about Dorrow. Darrell Brooks is a hot mess. Check my videos out. See, you know, if they were, you know, informational to let y'all know about some of the trials. But I will continue to do videos on Dorrow because there's so many pieces to this trial that we got to talk about, y'all. We got to dive up in this court case with Dorrow and his shenanigans. But you guys, thanks for stopping by. Like, share, and subscribe. And y'all, I'll see y'all on the other side. Bye.